We will speak today of labor law and foreign workers. In our system of labor law, there are specific rules regarding foreign workers that prohibit employment discriminations on the basis of nationality. This is a constitutional rule in Chile. However, as usual, conditions apply. Chile's labor law includes a chapter regulating the percentage of workers by nationality, reserving 85% for Chileans, counted as persons, not in relation with the total amount assigned to salaries. However, this rule is only for employers with more than 25 employees. That is to say, those employers with fewer than 25 employees do not have a limit on the percentage of foreigners hired. And this is for sure an interesting opportunity for foreign investment. Now, to calculate the rate of 85%, the labor law has the following specific rules. The total number of employer staff includes all those within the national territory and is based the various branches separately. This is important, the various branches separately. The calculation excludes technical specialists, foreigners with a Chilean spouse or child, or who are the widow or widower of a Chilean spouse will be counted as Chileans, and Chileans who have resided in another country for more than 5 years without taking into account accidental absences will also be considered as foreigners. In cases where foreigners are employed, the employment contract must include a clause in which the employer agrees to pay the repatriation travel cost of the foreigner and his or her family at the time the contract terminates. In those cases where foreigners are employed, the Ministry of Interior and Public Security authorizes the foreigner to stay in the country and undertake the activity expressly provided by law through a visa, which could either be granted subject to contract or temporary. Visa subject to contract is a permit that entitles the holder to work exclusively with one employer, the Chilean company who signed the contract that gives rise to the visa. The permit has a duration of 1 to 2 years and may be extended indefinitely. It is important to remember that the termination of relevant employment causes immediately also produce the expiration of the visa. For this, the contract to have legal effect in Chile, the contract should incorporate some specific clauses which relate to remuneration, commensurate position within the company, provision of return ticket to country of origin at the end of the period of work in Chile, pension contributions, income tax, and contract authorization from the immigration authority, which enables the foreigner to work in Chile. Now, let's talk of temporary visa. It's a permit granted to a foreigner who proves they have family ties to Chilean citizens, interest in the country, or whose residence is considered useful or advantageous. This residence entitles the holder to reside temporarily in the country and to conduct any lawful activity without special limitations. The duration of this visa is for 1 year and is renewable for 1 year only, after which time the holder must apply for a permanent resident. The application for a temporary resident visa can be based on different grounds. One very relevant case is the case of a company outside of Chile where the remuneration is paid abroad. That is, the benefit enables the foreigner to perform work functioning in Chile without a Chilean employer and without separating him or her from the contracting business in their country of origin or current resident. So you can still be paid and can make contribution for pension and health and the like in your country of origin. In relation to Social Security scheme, that is to say pension and health, technical personnel or foreign professional employed by legal persons are not required to make payment of any nature to Chilean welfare institutions, provided that the worker is enrolled in a pension or social security scheme outside of Chile, which grants benefits in cases of illness, disability, old age, and death. And in the respective employment contract, the employee expresses the option to maintain their membership in the respective foreign body. In order to apply to this exemption, the foreigner must establish their technical or professional status through certificates of title or a relevant degree duly legalized by the Consulate of Chile in the country of origin of the document. Application for a resident visa takes in Chile approximately 3 months to be awarded. 1 month after the application is entered, the Interior Ministry may authorize with a temporary work permit, which is valid until the visa application is either rejected or accepted. Thank you very much.